Ajay with those details. It was a day of emotions, celebration, as well as an open challenge for Aam Aadmi Party President Arvind Kejriwal, who's been given the clean chit by a special court in the 2022 Delhi liquor excise policy case. Arvind Kejriwal, who spent 5 months in jail due to the CBI's arrest, broke down in his first reaction. The CBI has challenged the acquittal in Delhi High Court. The court made some strong observations, slamming the CBI for a case that it said missed basic thresholds and also criticized the charge sheet. The BJP has called this a technical error and promised to continue the fight in court. Joining us live at this point is Sarvinder Singh Marwa, BJP MLA. Mr. Marwa, thank you for speaking with Newsx today on this day when the Aam Aadmi Party is, of course, celebrating in the national capital. Do you believe the bail granted by court has flattened the corruption case against Arvind Kejriwal, the case that you used in your rallies and party events?
क्या है कि सबसे पहले तो सीबीआई बार बार यही कह रही थी, आपने देखा जब भी इसको सम्मान किए, जब भी इससे बातचीत की, इन्होंने दोनों ने मिलके सभी अपने जो चिप है वो बदल दिए, चिपों को नष्ट कर दिया इन्होंने। अपने जो 20-25 चिप मनीष सिसोदिया जी के थे, मोबाइल अपने जो है बिल्कुल तोड़ दिए गए। मतलब इन्होंने सबूत तो पहले दिन से ही हटाने शुरू कर दिए ना। यही बार बार सीबीआई कह रही थी कि इनसे पूछो कुछ, कहते कुछ है। इसीलिए तो सीबीआई हमेशा यही कहती रही है। पहली बात तो ये है कि अगर इनकी शराब नीति सही थी तो उनको उसको वापस क्यों लिया। और सबसे बड़ी बात है कि पूरी दिल्ली को मालूम है, पूरे हिंदुस्तान को मालूम है कि जो एक्साइज ड्यूटी में रिश्वत खाई गई, केजरीवाल और मनीष ने रिश्वत खाई, ये तो क्लियर पहले दिन से ही है। बच्चे बच्चे को पता है, एक के साथ एक बोतल फ्री। जब से हिंदुस्तान आजाद हुआ कितनी सरकारें आई, कितनी गई, किसी ने एक के साथ एक बोतल फ्री नहीं की। और फिर सबसे बड़ी बात है, अगर आपने इसमें चिटिंग नहीं की तो आपने अपनी जो एक्साइज ड्यूटी वापस क्यों ली, ये बताएं सबसे पहले।
अरविंद केजरीवाल ने आज प्रेस से बात की। अरविंद केजरीवाल का यह दावा है कि सीबीआई और आपकी पार्टी भारतीय जनता पार्टी, तरविंदर सिंह मारवा जी, उन्होंने ये किया ताकि आम आदमी पार्टी खत्म हो जाए।
झूठ बोल रहा है, आंसू बहा रहा है, आंसू बहा रहा है। आपने देखा बड़े बड़े, जैसे पहले आंसू बहाता था, जब कोई इस पे चप्पल मार देता तो आंसू बहाने शुरू कर देता था। आज भी देखा आंसू बहा रहा है कि मैं बेकसूर हूं। अरे बेकसूर है तो ये बताए ना, बेकसूर था तो क्यों शराब नीति वापस ली आपने, किसके क्यों? अगर आप पे कोई रिश्वत का नहीं था, 100% केजरीवाल और मनीष सिसोदिया ने रिश्वत ली। अभी जो है सीबीआई और जांच कर रही है, और भी अदालतें हैं, और भी अदालतों में अभी ये मामला।
मगर मारवा जी, विपक्ष जो है वो लगातार ये आरोप लगाता है कि एजेंसीज का दुरुपयोग होता है आपके सरकार द्वारा। क्या आपको लगता है आज का ये नतीजा है वो विपक्ष के जो क्लेम्स हैं, आरोप हैं, उनको और बुनियाद देगा?
बिल्कुल गलत है, ना कोई सरकार का इसमें इंटरफेयर है। जो करेगा वो भरेगा, और जनता ने इसको सबक सिखा भी दिया है। बार बार एक ही बात अखबारों में आपने पढ़ी, टीवी चैनलों में, कि 25 फोन इसने बदले, और 25 के फोन में चिप इसने नष्ट कर दी पहले से ही। और उसके बाद इसका नाम क्या, जो टेलीफोन है वो भी अपने तोड़ के उसने फेंक दिए। क्यों फेंके, क्यों 25 चिप को उसने नष्ट किया? यही तो पहले दिन से सीबीआई कह रही है कि आपने ये सबूत जो है नष्ट क्यों किए। लेकिन रोने का बहाना करके मैं बेकसूर हूं, आंसू बहा रहा है, आज आंसू बहा रहा है। अभी इसको पता है पंजाब में मेरे हालत खराब हो रहे हैं, इसलिए ये आंसू बहाकर पंजाब में चाहता है कि मैं ईमानदार आदमी हूँ। लेकिन अब पंजाब में भी इसका पता ही नहीं लगेगा गया कहाँ पर है।
तरविंदर सिंह मारवा जी, अब ये खबर आ रही है आज कि अब इसे अपील किया जाएगा। क्या आप कॉन्फिडेंस है आपको कि आगे जाके जो है ये ओवरटर्न होगा, ये वर्डिक्ट, सीबीआई कैन सिक्योर अ कन्विक्शन इन द हाई कोर्ट? आगे क्या होने वाला है इस मामले में?
देखो, केजरीवाल जेल जरूर जाएगा, ये मैं आपको बताना चाहता हूँ, क्योंकि जो इसने गलतियां की हैं, अभी कोई ये नहीं कि इस छोटी अदालत में इसका फैसला आ गया, और भी अदालतें हैं। सीबीआई अब आगे जाने का विचार कर रही होगी, ये सीबीआई जाने, लेकिन मेरे को ये है कि इसने जनता को धोखा दिया है।
जी।
अगर एक बात स्पष्ट है, अगर शराब नीति ठीक थी तो इसने वापस क्यों ली? किसके डर के मारे वापस ली इसने? क्यों ली? क्योंकि ये अंदर से काला चोर था। इसने शराब घोटाले में
जी।
सब लॉबी जो साउथ इंडियन की थी, दूसरी थी, सब लॉबी को इकट्ठा करके फंड लिया, वो गोवा भेजा।
चलिए, शुक्रिया आपको हमारे संग जुड़ने के लिए। तरविंदर सिंह मालवा, बीजेपी MLA, speaking with us there. Let's bring in now former MLA and senior leader of the Aam Aadmi Party, Somnath Bharti, who's also joining us now. Somnath Bharti, obviously this is a good day for the Aam Aadmi Party. This is a day where you, of course, are claiming vindication. How do you view the verdict today?
So this is not a vindication only for Aam Aadmi Party. It's a vindication for every individual who trusts honest politics, who trusts politics or work-oriented, who trusts that election could be fought on the basis of good education, good healthcare, etc. So I'll just read one line. I mean, I was just listening to Marwaji from BJP. Let me first correct what he stated. The policy was taken back because of the LG that time. Now I come to the judgment. See, I mean, the way they are talking about the judgment, it's a lower court only, it's not a high court, it's not a Supreme Court. What is it? Are they discrediting judiciary today? Just because the judgment has come in a right manner? Let me quote now the judgment. Judgment is 600 pages. I doubt Marwa Saab has read the judgment at all. Para 83, gentlemen. Have you read the judgment? First of all, let me ask you. Have you read the judgment?
Absolutely. I've seen the main takeaways of it, yes.
So para 83 says what? It says very categorically. It says a closer examination within the contours permitted at this stage may reveal that facts have been arranged to support a predetermined conclusion. Can there be a bigger, statement against against all this thing which were done against us?
Right.
This is indictment. This is indictment of CBI and their ACA, BJP. Further, I mean, the entire case, it is so beautifully detailed, everything. And if you read properly, it says that, against Mr. Kejriwal, there is not an iota of proof within your possession. And it has gone further to state that you are mistaking that we are not here. It says categorically that if you start, I mean, there is one approver, there is one person who becomes the approver to the state. Para 102, if you read, that says that a approver after, I think, 12 or 13 times of so-called confession.
Yes.
And interestingly, none of the confessions was put before the court.
Okay.
So in one of the confession, he said, all right, because he bargained his freedom. It says, I mean, if you read specifically that, a paragraph,
yes,
you'll be amazed the way BJP has misused CBI.
Right. But we're already learning. We're already learning that the CBI is going to be appealing this. They're going to be going to the High Court. The BJP claiming that they're confident that, ahead, this is not going to hold. They're saying this is an aberration. There's some sort of technical error that has emerged and this will be overturned, this verdict. Are you confident that this is how it's going to remain in the High Court and then possibly the Supreme Court?
So kindly permit me to read that line which will possibly help your viewers. It says that where the prosecution case rests substantially or indeed exclusively on the statement of an approver, this duty of scrutiny assumes greater significance. An approver is a witness who was admittedly bargained for power and immunity from prosecution. His statement is therefore inherently self-interested. If the incriminating material consists solely of the uncorroborated statement of such a witness, it cannot ordinarily be regarded as sufficient to justify the framing of charge. Tell me, can there be a bigger indictment of BJP? So today, and this is further stated, and then I'll answer your question. It is said that Honorable Supreme Court in its judgments has said at the time of framing of charge,
Yes.
the court must see that the material put before the court should not only raise suspicion, it should raise grave suspicion. And then court further says,
Okay.
forget about grave suspicion, it does not even raise suspicion.
Okay.
Tell me. I mean, you on such basis, you prosecuted. I mean, you put a sitting chief minister in the jail for 5 long months.
Absolutely. He was in jail for several months. So you're confident. You're saying you're confident that this will hold then. You're confident this will hold the test ahead in the higher courts.
In high court, sir, let me tell you, whatever material was with the CBI, that has already been discussed at length in this judgment.
Yes.
High Court will not entertain any new material. Rather, they have no new material at all.
Okay.
So, a real appreciation of facts and the materials and the so-called evidences has already been discussed in that.
Okay. Mr. Marwa there made that point and you answered it briefly at the beginning. I want you to elaborate on that because that's what BJP is going to say. They're going to say if you felt everything was hunky-dory, if everything was clean and fine, why was the liquor policy withdrawn?
Yes, it was withdrawn because of Honorable LG. And that is what judgment also says. That was Masini Sisodia exclusively only on his own took a decision. There is a process. There is a TBR, Transaction of Business Rules of Government of Delhi. There is a Business of Delhi Allocation Rules. There is a Central Secretariat Manual of Office Procedure. All these were followed. And extensively, LG Sahab was involved.
Right.
So that the question was asked by Honorable Court to CBI that how come you could only accuse Manish Sisodia?
Okay.
Okay. So the problem is court has gone too deep. Court has evaluated every aspect.
Okay.
And court has concluded in a rightful manner that there is not an iota of evidence.
My final question.
Which can implicate Sisodia ji or Kejriwal ji even for
my final question to you. This is a charge that you all have been leveling for a while. Your party, of course, also the BRS's K. Kavita. I don't think she's with the BRS anymore, but she was, of course, when these charges were framed against her, that the BJP is doing this for political reasons. The agencies are being misused. That's a charge that the opposition levels often on this government. Do you believe today's verdict strengthens that charge? And do you plan to then take this further politically as well? Because this was raised against you in the Delhi elections and perhaps it has cost you.
Sir, this ill design or this sinister design was manufactured in the headquarters of BJP, and in that manufacturing, even Congress was involved. See, they tried their best because the problem is the Kejriwal model of politics, which is oriented towards education, healthcare, solving people's problems,
right,
could not be countered by BJP or Congress in the rightful manner. They have got no vision whatsoever for the country's schools, for the children's education, for the poor man's health services, for the employment, for the water, for electricity. So what did they do? They say, kill this man and kill his party. But there is a superpower, there is divine power. And we have always said that there is nothing bigger than Lord Shiva. Lord Shiva himself manifested today in the form of the judge and decided this case in a manner that BJP will not get a second chance to accuse Aam Aadmi Party in such a brazen manner.
Well, absolutely. That's what your leaders have said today, that you are a Kattar Imandar party, of course, though, but we'll have to wait and watch how this goes now. to the High Court, where there are indications it will go as well. All right, let's leave it at that. Mr. Bharti, thank you very much for joining us. Somnath Bharti, thank you very much for joining us with your perspective. Okay, let me also bring in now a legal perspective. Sumer Singh Boparai, advocate, is joining us now live on the broadcast as well. Sumer Singh Boparai, let me begin by asking you about the main takeaways. Just decode for our viewers the main observations today made by the Honorable Judge and the main takeaways of this judgment, where, of course, the court has concluded that all the accused, which include the former CM of Delhi, the former Deputy CM of Delhi, a prominent MLC of the BRS, former MLC of the BRS, and many other leaders also have been discharged, have been acquitted.
A very good evening to you, Uday, and all your viewers. Before I analyze the judgment, let's just understand what was the case. The alleged case was that certain people belonging to the south of our country had, in connivance with certain people in the north, tried to manipulate and change the policy to their benefits. In lieu of this, they have given kickbacks of about 100 crores. As far as the policy manipulation is concerned or interference is concerned, the Honorable Trial Court, as the predecessor speaker, Mr. Bharti, has mentioned, has categorically held that the policy is in consonance with 3 sets of rules which ought to be followed, and that there is no unlawful intervention or influence, there is no surreptitious authorization of any document, there is no incitement of any kind by any private player. Apart from that, as far as the aspect of kickbacks are concerned, being a part of this long and arduous battle and a sweet victory thereafter that we've received, the main allegation against one of the clients that I was representing from the south was that money had come from the south. There is not an iota of evidence with the CBI that shows this trail of money. Not an iota of evidence. What is the evidence for this? The evidence for this is their star witness, one Mr. Dinesh Arora, who gives a statement under 306 only to get that pardon because he was an accused. And he gives what is the law on 306? The law demands that the person, the accused, who's being tendered pardon, ought to give full and fair disclosure. Now, what has happened? Well, I'll just take a moment to inform your viewers as to how criminal trial and criminal investigation proceeds. A case is, an offense is committed, an FIR is registered, IO is appointed. He starts investigating the case, following the trail, has a case diary. As and when and as and how his investigation progresses, he names accused, arrests them. The new trend that we are seeing in this country is that these agencies are given targets already. That you have to target X, you have to target Y, you have to target A. Now, in a situation like this, who faces the wrath of the court? Evidently the IO, because there is no evidence. So what does the IO do? He manufactures evidence. Now, all along this investigation, Mr. Arora had already in November 22 given a fair and full disclosure for which he got a pardon. But now in 23 and 24, certain more people were to be made an accused as per the dictats.
So where do you see then, Sumer, that the case fell? Do you believe it was on the part of the investigation or it was on the part of, the testimonies of the approver not holding good in the court of law? Where do you see the case falling flat? Because this is now going to go for appeal. The CBI sources have already indicated to us it's going for appeal. BJP is also saying they are in favor of the appeal. They claim that this is an aberration, this is a technical error. और जो आप साउथ की बात कर रहे थे, मिस्टर मारवा was just saying that साउथ और नॉर्थ ने कंबाइन किया ताकि पैसे बनाए वो, और लिकर पॉलिसी वापस क्यों की? If there was no wrongdoing, prima facie.
South and North, why will South combine with North? In lieu of something? That is the allegation that I have given kickback. You read the order, there is not an iota of evidence that a single penny was sent from the South to the North. That is point number 1. Point number 2, yes, it is widely reported that they have challenged the order on charge, order discharging all the accused in the High Court. But let's be mindful of the fact that what is the remit, what is the ambit of this challenge? The evidence or the material which is already on record. There has been a threadbare analysis of the material on record. The material on record hopelessly fails to prove manipulation in the policy, to prove kickbacks being given, to prove any kind of inducement. So on what basis are they so hopeful to call it a technical error? IO not doing its duty properly is not a technical error, sir. State of Jamna Chaudhary versus State of Bihar 1979, the Honorable Supreme Court says that it is the bounden duty of the investigating officer to unearth the unvarnished facts and not to be a mouthpiece of the prosecution or the accused. So an IO not doing his duty properly, it is not a dereliction of duty. He has purposely conducted this investigation, created facts, manufactured facts. There is no technical error here. There is no irregularity under the CRPC which will not vitiate the process. This is much more than a technicality.
Yes.
There is no evidence. Like I said, the Honorable Court has said, leave alone suspicion, grave suspicion, there is no prima facie case made out.
So there was lack of essential evidence presented by the CBI is what you're
There was lack of essential evidence. And now you please understand one thing. The case started in August 22. 17th August 22 is the CBI FIR. There are 23 accused people in this matter. 15 out of them were jailed. Some of them spent more than 1 year in custody. Someone needs to ask these questions, that you are tarnishing someone's image. Basis what? Basis this whimsical, shoddy investigation where there is no evidence?
Okay. Now, on what stands out in the judgment finally? To you, I have to ask you, of course, there will be the politics. The Aam Aadmi Party is claiming vindication. I'm sure they'll take this to the people now. But the fact is that what stands out in the judgment to you today, which gives you the confidence that this acquittal is likely to stay even in the High Court and possibly the Supreme Court?
Every single piece of evidence has been threadbare analyzed and dissected to prove that no offense of 7A, 120B or 420 or 467 is made out. There is no evidence whatsoever. Not only Dinesh Arora, they made up 3-4 more approvers from the south.
Yes, they were
belonging
approvers.
to political family. One of this approver gave a statement against me that I had received, me as in my client, that my client had received 15 crore rupees from him in Chennai. The audacity of this guy, I must tell you, the statement he gives is completely contrary to the previous statement given by him to the CBI, which was not relied upon by them initially. It was only subsequently brought on record after 1.5 years. And in that statement, that gentleman says that I have never met Abhishek Boinapalli in my life. This is the kind of contradictions, manufacturing of facts, and the perversity that is there in the evidence.
Okay.
Uday, we cannot, the government, the agencies cannot build castles in the air. They have to substantiate their allegations. They have to build an edifice on which this entire case stands.
All right. All right.
Not be a figment of their imagination.
Okay, this was a figment, the charges were a figment of the imagination and you're saying the case has fallen flat. All right, thank you very much, Sumer Singh Boparai, for joining us there with the legal perspective on this case now. Let's get in the agency perspective on this case now. ML Sharma, former Special Director CBI, is joining us live. Mr. Sharma, why do you think the CBI could not prove this case against Arvind Kejriwal and the others?
So, fact of the matter is that it is more than 500 pages long judgment. I have not read the judgment thoroughly. Crux of the matter, according to my understanding, is that there was no money trail. You see, when there is a charge of under the Prevention of Corruption Act, then quid pro quo has to be established, that the policy maker or the public servant, be he a politician or a public civil servant, he acted in a particular manner for a particular consideration. Now the judge is very right in saying that policy making is an experiment. Sometimes the policy may succeed, sometimes it may fail. It doesn't mean always that if a policy has failed, it is because of corruption. I am not in a position to say whether or not there was actual corruption in this whole transaction involving 23 accused persons and hundreds of witnesses and all parts of the country virtually. But I'm of the firm view that quid pro quo, that is money trail, could not be established. That is the accused name in the charge sheets, 4 charge sheets, that they got some money from the principal characters or the accused persons involved in this case. According to me, this is the main deficiency in this case. I also would like to add that the case built up by the CBI was essentially based on the testimony of the approvers. Now, approvers are persons who are involved in crime, but they seek pardon from the state and become state witnesses. Now, since they are privy to the crime and they themselves have participated in the crime, you see, their evidence is always taken with suspicion unless the approver evidence is corroborated in material particulars. It is not accepted by the courts, and no conviction can be based only on the approval evidence unless there is supporting evidence. Now, here, what has happened is trial has not taken place, witnesses have not been examined, they have not been subjected to cross examination, yet the court has discharged them, saying that, meaning thereby that trial is not necessary in this case. So the court order may be right in the sense that there is no direct money trail, but the trial has not been allowed to take place. So therefore, this leaves enough scope for agitating this matter in the higher judicial forum, that is the High Court. This is my prima facie view.
What do you think then was the essential evidence presented by the CBI in court? Obviously, that has not really been accepted by the court, but what was that evidence presented by the CBI, Mr. Sharma?
See, this evidence I am saying, these days, you see, the judges are fond of writing long judgments so that they are not read. Now, judgment has just come out today. Of course, I was going through a judgment and some excerpts I have taken from there. Now, unless I absorb these 500 and 600 pages, I can't tell you in great detail as where the CBI failed. But this is my prima facie view that there was no direct evidence of quid pro quo. If it had been proved that accused A, and there are 23 accused, or accused B or accused C, accepted so much money from accused X or accused Y or from some people,
yes,
who are beneficiaries in this deal, then I would have been able to answer this question. But this is not the case.
Okay.
This is my exercise understanding of the whole matter. So I can't really comment in detail about the CBI failing to prove.
But today's verdict, Mr. Sharma, do you believe it's a setback for the CBI?
See, CBI handles thousands and thousands of cases every year, and for Delhi people it may be a very important case, but there are much more important cases of CBI, and it's not always possible to succeed in the courts.
Right.
And therefore, I don't consider it as setback, let alone a major setback. Also, please remember that the court verdicts are not the verdict of the trial court is not the final word. You may remember or you may recall that Priyadarshini Mattu case, despite DNA evidence, the trial court acquitted the accused. Yet in appeal, a Delhi High Court gave hanging to the same accused. And of course, in the Supreme Court, he was given life term as he is undergoing life term, the accused person. So therefore, this word coming from the trial court is not yet the final word. And therefore, to say that it's a colossal failure of the CBI at this stage is not correct.
Okay.
And also, please remember, every case can't succeed.
Yes.
If every case has resulted in conviction, then trial courts are not necessary at all.
Absolutely.
Simply charge sheet will be a court order. It will be taken as a court order.
What
So
happens
it's not a
next now?
setback.
What options are available before the CBI? What are you seeing happening next?
This is only one option. There is only one option, and I am very sure that CBI will go to the High Court to say that this discharge is unfair. Whether or not they succeed or not is a different matter, and therefore the High Court should consider this matter afresh, and it will be reconsidered afresh
Now,
by the High Court.
Political vindication is being claimed. Several politicians have been acquitted today. They've all been acquitted. They're claiming vindications. What do you believe is the reason of all this corruption taint now? Going from these leaders today who of course have been targeted, but now today are claiming vindication.
Not correct. You see, prevention of corruption cases, they take 20 years to dispose of, and therefore the whole thing gets obliterated. Some cases are acquitted, some cases are convicted. So I am not attributing any motive to anyone.
Yes.
Neither to CBI nor to ED. But all that I can say is that over-enthusiasm in the investigating agencies, particularly CBI to a lesser degree and ED in a greater degree, over-enthusiasm is not desirable.
Okay.
They should follow the line of law. They should call a spade a spade.
Right.
Otherwise,
ML Sharma, I appreciate you joining us with your view on this big story. Of course, ML Sharma speaking with Newsx there. He's been former special director of the CBI. All right, we try to give you all perspectives on this big story that has come out of the courts today in the national capital. And we're going to leave it at that. We've run out of time. Let's take a break.